Yes, this is Attorney Tuttle. I was just retained on a person that I believe is on your court date, on your calendar, Mr. Harris.
The State of Michigan, City of Detroit, 36th District Court is now in session. The Honorable Judge Aliyah Sabree is presiding. Good morning, Your Honor.
Good morning, everyone.
Morning.
Let's start with Mr. Halsey. Okay, we're on the record. This is case 235-6604, the people of the state of Michigan versus Michael Lynn Halsey. Mr. Halsey is charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, set for a probable cause conference.
Evidence to walk with C54828, appearing on behalf of the people.
Zoranic P39346 for Mr. Halsey. Please state your name, sir.
Michael Lynn Halsig.
Okay, and
Judge, I did explain to Mr. Halsey his right to an exam. He wishes to waive it at this time, be bound over to circuit court for further proceedings.
Can you repeat that? I didn't hear you. I was talking.
Oh. Judge, I did explain to Mr. Halsey his right to a preliminary exam. He wishes to waive it at this time, be bound over to circuit court for further proceedings.
Any objection from the people?
No objection.
Okay, Mr. Halsey, can you hear me okay?
Can you repeat that, please?
I just asked if you can hear me okay.
Yeah.
Okay, I'm going to ask you a series of questions. If you don't understand my questions or if you can't hear me, please let me know, okay?
Yes.
Is it your wish to waive your preliminary exam today?
That's correct.
Do you understand you have a statutory right to a preliminary exam?
Can you repeat that?
You understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam, the people would have to show the probable cause standard, which is a much lower standard in criminal law, but still a standard, that the charge I read off in the information and complaint was committed in the city of Detroit and that you probably committed that crime. Do you understand that?
Yeah.
And then by waiving your exam today, that means the people do not have to prove anything at the probable cause standard. You understand?
Yes.
You also understand that you're not giving up your right to trial.
Yeah.
Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Mr. Halsey, you'll be bound over to Third Circuit Court, Frank Murphy Hall of Justice, for the arraignment on the information for May 19th at 9:00 a.m. Bond is continued, and also Attorney Duranic and Mr. Halsey, do I wish to sign your names on the waiver form since you are both virtual?
Yes, Your Honor. Thank you.
Okay. Okay, you're all set, Mr. Halsey. You can log off.
Okay, thank you.
Have a good day.
Thank you, Your Honor. Have a good day, good weekend.
Thank you. You too.
Your Honor, this is Attorney Tuttles. I have a quick question for Madam Clerk.
Okay, she's not even talking to the prosecutor right now.
Okay.
Any other attorneys ready on their case?
I'm ready on mine.
This is Attorney Dan Bitar. I'm ready on James McCray.
Do you still have a question, Attorney Taylor, or are you ready on your case?
Judge, I'm ready on Calhoun, who's in the Wayne County Jail.
Okay. Good morning.
Your Honor,
Yes.
this is Stephanie Carson on Jovan Reed. I don't see my client, so I'm going to go mute and try to make calls to locate him.
Okay. Is Jovan, yeah, all right, I have Attorney Roberts on here. You were retained?
I was retained in, yes.
Okay, all right, I have it. So let's have a McCray first. We're on the record as the people of the state of Michigan versus James Arthur McCray, case 2356622. Mr. McCray is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, felony firearm, count 3, weapons, ammunition, possession by a felon, count 4, weapons, felony firearm, count 5, weapons carried concealed with a habitual offender, 4th offense notice set for a probable cause conference. The appearances.
Edwin Zawaki, P5488, appearing on behalf of the people.
Good morning, Your Honor. Daniel Batar on behalf of James McCray. There should actually be a second case. He has 2 cases that are scheduled for today. One was in Judge Giles, one was in your courtroom, Your Honor, and they both need to be combined into your courtroom.
That is correct. Also, case number 230566221. And on this case, Mr. McCray is charged with count 1, firearms possession by a felon, count 2, weapons carried concealed, count 3, weapons felony firearms with a habitual offender 4th offense notice. Thank you for that.
You're welcome. Thank you. Your Honor, Mr. McCray is currently incarcerated in the Wayne County Jail. I met with him. I would ask the court to waive his presence.
I will waive his presence if you have been in contact with him.
Thank you, Your Honor. And after speaking with Mr. McCray, it's pretty clear to me, Judge, that he needs to be referred to the Forensic Center on both these matters for competency and criminal responsibility.
Okay. So they're a little behind. I'm guessing about 60 days we should come back.
That works for me, Judge.
Get you an exact date. Can you do July 12th?
I cannot do that week. Is it possible to do the following week?
That's fine. July 19th?
Yes.
Okay. So I will set both for a competency hearing for July 19th at 9 o'clock.
Great. Thank you very much, Your Honor.
You're welcome. Weekend.
Take care.
Your Honor, I am back. I'm sorry. I have to leave.
Are you ready or do you need to speak to the clerk?
I just want to make sure that Ms. Dooley is scheduled in there today. I don't need to speak to the clerk. You just, the clerk can tell me whether or not Ms. Dooley is scheduled. On
She's here.
this document. Okay, then yes, I'm ready.
Okay, you were saying, is that correct?
Yes.
Okay, give me 1 second here. These two are I'll, fill out this.
Okay.
Okay, we're on the record. This is the people of the state of Michigan versus Roger D. Dooley. Case number 1264242. Ms. Dooley is charged with 1 count of uttering and publishing counterfeit bills or notes set for a probable cause conference today. Appearances.
Edwin Zawaki, P5488, appearing on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles on behalf of my client. That's Mr. Rondra Dooley, who is physically not present in your courtroom at this time. However, Ms. Dooley is present via Zoom. Ms. Dooley, can you wave your hand and identify yourself for the record? Say your name for the record, please. Okay, I think she's muted, Your Honor.
Ms. Dooley, go ahead and unmute your device.
Rodra Dooley, Your Honor.
Thank you.
morning.
Okay,
Okay.
Your Honor, we do have, yes. Can you hear me?
Yes, you said you have discovery.
Yes, we have discovery on this matter. You know what, let me be clear, Your Honor, because my clerk informed me that we do, but she may be confusing that with another case. So can we adjourn the PCC to make sure I have discovery on this case?
No, can we just, you can come back after you get confirmed with your clerk later on the day?
Or can we just ask the prosecutor to make sure he sends it over today and we could just set this for an in-person exam? I don't want to drag this out. And my later on today is impossible.
Mr. Sawaki, any insight on discovery?
This is an old case, we're having trouble tracking it down. You can email me tomorrow. About Monday. We'll see what we've been able to do.
So is the prosecutor saying he doesn't have a file?
He's saying that it's such an old case that he may not even have discovery on it.
So it's over 10 years old. So.
Okay, so can we set this for in-person exam?
Okay, that would be, it's scheduled here for May 12th. That's a Friday.
That's,
Can you do that?
we could do it next Friday, yes.
Okay, so let me give you a time. Give me Can you do 9 o'clock?
I could do 9 o'clock.
Okay.
Wait a minute, let me know what, give me a check, I apologize, because this is
Go ahead.
for, this is for in person, I want to make sure it's not on Zoom. One second, sorry. I could do May 12th at 9 o'clock.
Okay, Ms. Dooley, your exam is set for May 12th at 9 o'clock a.m. in person at 36 District Court. Good?
Yes, ma'am.
Okay, anything else for the party?
No, Your Honor.
Okay, you all have a good weekend.
Thank you.
That's good stuff. Come in when you get ready to talk.
Just wanted you to know, that's all.
Thank you. That's him up there.
So, yeah. So he represents.
Mr. Calhoun, good morning.
Good morning.
Attorney Robinson, you ready?
Ready.
Okay, this is case 2356601, the people of the state of Michigan versus Delon Calhoun, charged with count 1 as defendant 1, carjacking, count 2, robbery armed, count 3, conspiracy to commit stolen property, receiving and concealing a motor vehicle, as well as count 5, stolen property, receiving and concealing a motor vehicle, count 6, motor vehicle unlawful driving away, count 7, weapons carrying concealed, count 8, 9, 10, 11, all weapons, felony firearm with no provision offenders. Set for a probable cause conference appearances.
Your Honor, my apologies, I'll stand in. This is actually a specialty in this case, but Daniela Parrish, on behalf of the people, P85495, standing in for APA Doherty.
And good morning, if it may please the court, Sarah Robinson, P63181 for Mr. Calhoun, who's present from the Wayne County Jail. Sir, please state your name.
Ron Calhoun.
Okay, Attorney Robinson, do you have discovery on this case?
Judge, I did receive a download. I do need more time to review it. I'm gonna ask that I can submit a general discovery order. If there's any specific items I need, I will inform the people. At this time, I am asking that my client be referred for a competency. I have met with him 2 times, once in person at the Wayne County Jail and once on Zoom. And based on information he's provided to me, I would ask that he be evaluated.
You want competency and criminal responsibility for the future?
Well, they're just gonna do the competency first. So that's all I'm requesting is competency right now, Judge.
Okay. All right, so I just gave another date of July. Let's see what they are. 19th.
July 19th, that's fine.
Okay, we'll do 9 o'clock.
Yes, that's fine. Also, Judge, can I get a bond report from pretrial services, a DSU report?
I've ordered DSU
For
report
bond.
as well.
Thank you.
Okay, anything else?
No,
Okay, we're all set on Mr. Calhoun. Mr. Calhoun,
thank,
Yes,
did you state your full name for the record already?
yeah.
Do you have a middle name?
Oh, it's Daylon Sove, Nicholas Calhoun.
Okay, thank you. Okay, so I don't know if you heard your attorney is asking for a referral for competency. So we'll be back here on July 19th at 9 o'clock to discuss the results of the evaluation, okay?
All right,
All right, have a good one.
same to you.
Thank you. Okay, any other attorneys ready? I believe Attorney Carson.
Good morning, Your Honor. This is Robert Cantor. I've got Brian Roman Viejas. I have not received discovery, so I don't know if he's on Zoom or not. I have talked to him. I would have asked for an adjourned PCC.
Let's get on the record. Have you talked to your client at all?
I have, Your Honor.
Okay. What is your client's name?
Brian, then Roman Viejas.
Oh, here we go. Okay. Okay, we're on the record. This is the people of the state of Michigan versus Brian Mead Roman Viejas, case 2356586. Mr. Roman Viejas is charged with count 1, weapons carrying concealed, count 2, police officer fleeing forfeit vehicle code, penal code. Count 3, police officer assaulting, resisting, and obstructing step for a probable cause conference today. Appearances.
Good morning, Honor. Daniela Parrish on behalf of people, P 85495.
And good morning, Your Honor. Robert Cantor, P24993, appearing on behalf of Brian Roman Viejas. I'm not sure if he's on Zoom or not. I did speak with him, and if he is not there, I would ask to waive his presence.
I do not see him in the Zoom meeting.
Your Honor, at this point, I have not received any discovery whatsoever, so I would request the discovery and ask for an adjourned PCC date.
Any insight on discovery, Mr. Salaki? Or, I'm sorry, Ms. Parrish.
I'm just checking here, Honor, 1 second. At this time, the people have no digital to provide. If defense believes based on the report that there may actually be digital, you can directly email me today and I will reach out to the OIC to find out what has transpired.
Okay, I haven't received any paper discovery either, so I don't know if it refers to any digital, but
If you could email me, I'll get, I'll find out what. It's APA Parrish, DPERIC at Wayne County.
okay. And Your Honor, could we get another PCC date then?
Yes, but I still want to set the exam date.
Oh, okay.
Let's see, it's set for the 11th next week. Since you don't have discovery, I will stretch it out a little bit for you. How about the 15th?
Your Honor, I'm going to be out of town all next week and won't return until the 15th. Could we set it for the week of the 22nd?
I'm going to be out that week.
Oh.
Can you do the 17th?
I could do the 18th.
Where everybody's in training. All the
Oh.
judges are training. 18th and 19th.
17th, I can't do.
Okay, how about the 25th?
25th works.
9 o'clock?
9 o'clock.
And then we'll set another PCC 1 week from today. So that'll be, can you do May 12th for a PCC?
Oh, that'll be by Zoom. Well, I'm gonna be out of town all next week and I won't even have a chance to, wow.
It'll just be
Yeah,
you can send an email to the court with the
Okay.
prosecutor on it.
okay. I can do, we'll do it for next week then, the 12th.
Okay.
Good morning, Your Honor.
Thank you, Your Honor.
Okay. You're welcome. I'll send on Mr. Roman Viejas. Have a good one.
You too.
And Deputy, good morning.
Good morning. Are we done with Mr. Calhoun?
Yes, we are. Do you have anybody else?
I'm sorry, I didn't hear that.
Do you have anyone else in custody for this courtroom?
I don't believe so.
Okay, thank you.
Thank you. Have a blessed day.
And good morning, Judge. This is Attorney Andrew Sullivan. I'm here on Patrice Jackson Williams. We're ready as well.
Okay.
Your
Thank
Honor,
you.
I'm sorry.
Yep, I see your clients here. I'll call you next.
Thank you.
Calling case 2356614, the people of the state of Michigan versus Patrice Jackson Williams. Ms. Jackson Williams is charged with one count of assault with a dangerous weapon, felonious assault, that probable cause conference day appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, 385-495.
And good morning, Judge. Neighborhood Defender Service by Andrew Sullivan, P84261, here representing Patrice Jackson Williams. Ms. Jackson Williams, can you state your name for the record?
Good morning, Your Honor. I'm Patrice Jackson Williams.
Good morning. Attorney Sullivan, do you have discovery?
Judge, I do have paper discovery. Paper discovery indicates that the complaining witnesses did not wish to prosecute. I don't have digital discovery, but I am wishing to schedule the case for a preliminary exam. I'm available on the 17th, if that exam date is still available.
The exam day schedule is for May 12th. Can you do May 12th?
I can also do May 12th, yes.
How about 9:30?
That'll work, Judge.
Wonderful. Ms. Jackson Williams, your preliminary examination has been set for an in-person preliminary exam, May 12th at 9:30 a.m. at 36th District Court. You understand that?
Yes, ma'am.
Okay, anything else from either party?
Your Honor, the people would just like to indicate the digital was sent yesterday, but to the NDS general email, so defense may want to check that.
Excellent. Thank you, Ms. Parrish. I'll make sure that I have that. Thank you.
And if there's any questions or issues, feel free to email me right before, and I can give you an update about the other matter that you mentioned as well.
Okay, very good. Thank you.
Okay, Reed and then Bell. People of the state of Michigan versus Jovan Tino Reed, case 2356359. Mr. Reed is charged with count 1, weapons carrying concealed, count 2, weapons, felony firearms, second offense, count 3, weapons, firearms, possession by a felon with a habitual offender, fourth offense, notice set for a probable cause conference today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, P85495.
Good morning, Your Honor. Stephanie Carson on behalf of Jovan Reed. We consent to conduct this hearing via Zoom.
Mr. Reed, can you state your name, please?
Javon Reed.
Thank you. Attorney Carson, do you have discovery?
I have paper discovery. Mr. Roberts forwarded to me. I don't have digital, but I would like to set the matter for exam.
Okay, the exam date here is. Can you do May 15th or 16th?
Yes, I can do either.
Let's do the 16th. 9 o'clock?
Yes. Can I do 9:30, Your Honor?
That's fine.
All right.
Okay, Mr. Set for in-person preliminary examination, May 16th at 9:30 a.m. in person. You understand that, Mr. Reed?
Yes, ma'am.
Okay, anything else from either party?
Your Honor, may the people ask defense, Ms. Carson, I'm sorry, I can't see the writing on there. It's a little small. For the first name and P number, because we did send discovery, but we sent it to Roberts. So I want to get that out to her today.
I'll put it in the chat, Madam Prosecutor.
I'm in person. Just tell me your first name and your P number. I'll write it down real quick.
Stephanie 57096.
Thank you.
Thank you. Thank you, Your Honor.
Thank you. Have a good weekend.
You too. You can log off,
Reed.
Mr. Reed.
Mr. McCray,
Yes, ma'am.
morning.
Morning.
Your attorney he already logged on at 8:30. I have to get your file to see what happened. Damn date. Give me a second.
McCray, Your Honor, was the competency request for July 19th. Yes. Is it McCray? 92 files.
Yes, ma'am.
That's in July 19th.
Yes.
Okay, so your attorney requested a referral for you to be evaluated for competency. So there will be someone that will interview you and discuss the process of trial and several things. And based off of your interview, a report will be provided to the court, and I will make a determination as how to move forward with your attorney. So you will have to come back on July 19th at 9 o'clock to discuss that report. Okay?
Yes, ma'am.
You're all set, Mr. McCray, today. Oh, Attorney Moss, I know I said I would call your case next, but we got 4 defendants on your case. I want to make sure nobody else is on the docket for today before I call it.
I'm sorry. Okay, good morning.
Good morning.
Good morning.
Good morning, Your Honor and staff.
Good morning. Okay, we can call Bill. Mr. Jawan Bell, go ahead and unmute your device and start your camera. This is case 2356258, the people of the state of Michigan versus Jawan Tyree Malik Bell, who is charged as defendant number 3 with count 1, possession of burglar's tools, count 2, breaking and entering a building with intent, set for a probable cause conference today. Appearances.
Good morning, Your Honor. Danielle Parrish on behalf of people P85495.
Good morning, Your Honor. May I please the Sergeant Court Vanessa Moss, P63901, representing Mr. Jawan Tyree Malik Bell.
Mr. Bell, can you state your full name for the record, please?
Jawan Tyree Malik Bell.
Thank you. Attorney Moss, do you have discovery?
Your Honor, I do not have discovery, and I have not had the opportunity to speak with my client as I did not have a telephone number. So, Your Honor, I'm asking for another date for the PCC so that I can have the benefit of going over discovery with my client and speaking with my client.
Okay, has discovery been, or do you have an update, Ms. Parrish, on discovery?
Your Honor, my apologies.
Sure.
Your Honor, if I may ask defense counsel to email me directly today, and I will get down, figure out what is transpired with the discovery and why it's not been submitted to you.
I'm sorry, I didn't understand. You asked me what now?
Sorry, would you mind emailing me this afternoon if you don't have it before this afternoon, and I
Yes.
can find out what it is? Okay.
Yes, can I
Thank
get
you.
your email address, please?
Yes, ma'am. It's D as in David, P as in Patrick, E as in Edward, R as in Robert, I as in Igloo, C as in Charles at waynecounty.com.
Okay, DPER ICHARLES at Wayne County. Okay.
Whatever that ending part that you said after the C, don't put that in. There's no HR or whatever.
Disney Parish, right? Yeah, Wayne County.
The judge is gonna put it in the chat for you.
Awesome. Awesome.
I apologize for that delay.
Is that
No problem. And Mr. Bell, could you give me a number? You didn't provide a number.
Do you all want to talk in the breakout room after we get done?
Yes, that'd be great.
Okay, so let's set a date. Is this, do you have any idea what the discovery looks like, Ms. Parrish? No? Okay. Let's come back on, can you come on May 10th?
That's my birthday. Yeah, I can do May 10th.
We can do a different day. We can do
No,
11th.
that's fine. I'll be here early.
That's both our birthday. That's crazy.
Conference to discuss discovery, okay?
Okay, thank you.
You're welcome. You're welcome. You're all set, Ms. Bell.
Are you going to put us in a breakout room, Your Honor?
Yes, thank you.
Okay, thank you.
Attorney Watt, your client already logged on with Attorney Tuttles.
Okay, thank you, Your Honor.
You're welcome. Have a good weekend.
You too.
Mr. French, have you talked to your attorney?
Only through the phone.
Can you call him, please? He was just on here, but he logged off. Reach him first so we can call your case.
Okay, no problem.
And Attorney Salaka, good morning.
Good morning, Your Honor. So I just spoke with my client, and apparently the warden over there was not informed that he had a Zoom hearing this morning. If someone could maybe contact the warden's secretary, he said they can arrange for him to be on a Zoom hearing in relatively short order.
Okay. Give us about, you get about a half hour?
No problem. Would you like me just to log back on at that point?
Yes. We have a lot of PCCs today.
Okay. All right. No problem. Thank you.
Officer Brown, good morning. His name.
Good morning.
I believe you should be in court 332 of Judge Larry Williams. Do you have a traffic matter?
Yeah, 332.
Yes.
Okay, thank you.
You're welcome.
Excuse me, Judge. Just a quick question from Wayne County Jail.
Yes, good morning, Deputy.
Good morning. Just a quick question. Are you all set with McCray?
Yes, we are.
Okay, thank you so much. Have a good day.
You too. Okay, ready on Smith Henderson?
Ready, Your Honor.
Okay. Ms. Smith Henderson, how do you say your first name?
Unaje.
Okay, I'm glad I asked. Okay, people of the state of Michigan versus Unaje Ms. Henderson, case 2305657-401. Ms. Smith Henderson is charged with one count of police officer assaulting, resisting, and obstructing with the habitual offender second offense notice set for a probable cause conference. May I have appearances?
Good morning, Your Honor. Daniela Parrish, on behalf of the people, P85495.
May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit. On behalf of Ms. Smith Henderson, Ms. Smith Henderson, please tell the judge your name.
Unaje Smith Henderson.
Good morning. Attorney Noakes, do you have discovery?
I have all the discovery, Your Honor, and we're requesting an in-person preliminary exam.
Okay, the date I have here is for May 11th. Does that work?
Depending upon the time, Your Honor, I currently have 2 exams scheduled at 9:15 in Judge Jefferson's courtroom, so I could be in your courtroom shortly thereafter.
Let's see. How about 10:30, 11 o'clock?
10:30 would work just fine. Your Honor, if I may address a condition of bond at the moment.
Sure.
Your Honor, Ms. Smith Henderson is on house arrest, and given the nature of the offense with which she's charged, I don't believe house arrest is appropriate. She has a GPS tether, and I think that would simply be sufficient to make sure that she's not a danger to the community and that she will return to court. I don't see the need for the house arrest, and I'm asking you to release her from the condition of house arrest.
Anything from the people?
Based on limited information and events that's provided, I would defer to the original bond that was set and object to any modifications at this time.
Okay. I'm going to remove the house arrest condition. Ms. Smith Henderson, do you work?
I'm not able to work at the moment because of the condition. I have jobs lined up and I had jobs lined up, but I had to turn them down due to the condition. But I am able to work. I'm not working at the moment though.
Okay, so what type of industry or what type of work?
Warehouse work. That's what I'm doing at the moment. That's the type of work I do at the moment.
Okay. I'm going to put a curfew on. I'm trying to figure out what type of jobs you're getting, or if you're going to be employed, what type of work you're going to be doing.
It'd be different shifts, like first, second shift. I could run it by the court, because I haven't picked up any shifts lately because I didn't want to keep having to turn them down. So
Ms. Smith Henderson, Your Honor, I think it might be appropriate at this point to allow her out from 6 a.m. to 6 p.m. and we should be able to adjust that based on additional information when we arrive in court on the 11th.
Okay, I'll do 6 a.m. to 10 p.m. She's allowed out.
Thank you, Your Honor.
Anything else?
No, Your Honor.
Okay, have a good one.
Thank you. You too. Ms. Smith Henderson, I'll be in touch with you before we go to court on the 11th.
okay, thank you.
All right. You're welcome. Bye-bye.
Bye-bye.
Mr. French, did you speak to your lawyer?
Yes, I did. said he was in the lobby, but the clerk ended up sending him somewhere else. So he said he's getting back on now.
Okay, we don't even have the ability to send people other places, so I don't know. That was. But I'll bring him in as soon as he logs on. Attorney Chambers?
Yes, Judge, good morning.
Good morning. Yeah, Mr. Chappelle?
Yes, Mr. Chappelle. I believe that's the Attorney General's office. Ms. Shawn Ryan, I believe, is on that matter.
That is correct. Good morning, Your Honor.
Good morning. I don't see him on the docket today. Give me a second.
We were here last week, Judge. That's when I was appointed, and we moved this date from a prelim date to a PCC date.
Thank you. I remember now. It was never changed. It's on here as an exam. Okay.
Why don't I hear anything?
See, Mr.
Okay, let me call the case after I print it out. This is case 2606481, the people of the state of Michigan versus Rufus Chappelle, charged with embezzlement $50,000 to $99,999, set for a public appearances.
Good morning again, Your Honor. Assistant Attorney General Shawn Ryan, P54037, appearing on behalf of the people.
And good morning, Arnie Chambers, P63956, on behalf of Mr. Chappelle, who appears by Zoom. Would you state your name, Mr. Chappelle?
Rufus Chappelle.
Okay, and I am now refreshed. My memory's refreshed. I remember what happened here. Attorney Chambers, do you have discovery on this case now?
Yes, Judge. I may be off by a day or so, but I believe the discovery was sent to me Wednesday. As Ms. Ryan stated last week, it is extensive, Judge. I mean, I confess I've not had an opportunity to go through the discovery at this point. I would likely be needing to get an expert to organize this discovery for me, and I will start working on that today. What I would ask the court is if we could set a preliminary examination, I would say in 3 weeks.
Due to the discovery volume, I will do that. We won't be here. Oh yeah, we will be here. Does May 26th work?
I believe so. 1 second, Judge.
Your Honor, I'm unfortunately, as my grandma's memorial service that day, and Friday and Saturday, I will be out of town for that. I'm not available. I apologize.
No need to apologize from my end. I'm sure the court won't have it.
How about the 31st of May?
Judge, that's the day that I have a trial scheduled, a homicide scheduled to start in Macomb. I don't know if we're going to go on that day, but I would be available before that.
Counsel, may I ask, would you be interested at all in possibly requesting from the court another PCC date to go through the discovery and perhaps have a conversation, or do you know?
Yeah, no, and that was another thought that I had. If I don't know if the court wanted to set a prelim date and maybe set another PCC date in the interim. In looking at it on first glance, I'd have to let Ms. Ryan take the lead on that. She obviously knows more about it than I would at this point.
And counsel, to be honest with you, I even had a meeting with Mr. Polk in person to go through discovery with him, and you know, and I would be more than happy to do that with you as well, as paper cases are kind of sometimes hard to decipher just getting a bunch of Excel spreadsheets and documentation without putting context to it. So I have no objection to you. I know this case is old, Your Honor, but I have no objection to counsel taking whatever time he needs, and I'm here to answer any questions. And again, like I said with Mr. Polk, I did meet with him and would be happy to do so with you as well.
I mean, and Judge, I would appreciate that, because I'll tell you, when I first opened this up and glanced through it, I quite frankly didn't know what I was looking at. I didn't have a lot of time really to put into it. But there's a number of documents sent in a number of different files and in a touch of a bit of different format than what I'm used to getting. But it's there.
Okay, so tell me what, I do want to set an exam date as well. So what date would you like for a PCC?
How much time do you need to go through it and based on your schedule, perhaps meet and discuss the matter and then go from there?
A couple of weeks, Judge. I'm going to get an expert assigned, I believe today, whenever I get out of circuit court, to help organize this discovery for me. It's going to take him a few days to get that done. So
May 19th.
I'm sure I can make that happen. 1 second, Judge.
I am not available that day either. I apologize.
Okay, can you all just let me know what day works?
Or perhaps sometime in the beginning of June, counsel.
June is fine.
Okay, that's fine.
I'll go off your availability, Ms. Ryan. I just would say that I have a trial starting on the 22nd of May that should last 3 days.
Is the court available the morning of May 25th? That's a Thursday, or does the court do them only on Fridays?
Oh, we do them every day.
Every day, okay.
That works for me.
A PCC on May 25th in the morning?
Yes, let's do it, 8:30.
That's fine, Your Honor.
Thank you, Judge.
And then we'll discuss the exam date if need be on that day.
Thank you, appreciate it.
And counsel, I believe you have my email address if you want to shoot me an email, and I can, has my phone number on it as well, and we can connect well before then.
Will do. Thank you. I appreciate the time.
Sure. Thank you, Your Honor.
You're welcome. You have a good weekend.
You as well.
You're all set, Mr. Chappelle. We'll be back here on May 25th at 8:30 a.m.
All right, thank you.
You're welcome.
Everyone have a great day.
You too. Okay, let's see. Anyone else ready for their case to be called?
Your Honor, this is Brian Gagnick. I believe I have at least one matter, maybe two in your court. Can the court inform Demetrius Johnson, third counsel?
I'm sorry, I didn't hear your audio went out. I heard Demetrius Johnson. What about him?
Did he hire counsel?
It doesn't show that he did. It just has here that he has a neighborhood ADS attorney.
And that's me. I know my other client is in the Zoom chat or Zoom room, excuse me, and that is Jeremiah Stone. We're ready.
Okay. Jeremiah Stone. Stone first. Okay, we're on the record. This is people of the state of Michigan versus Jeremiah Lamont Stone, 2356197. Mr. Stone is charged with count 1, stolen property, receiving and concealing a motor vehicle. Count 2, police officer, fleeing for vehicle code set for a probable cause count for appearances.
Edwin Sawaki, P54828, hearing people.
Brian Gagnick, Your Honor, Neighborhood Defender Service, 64220.
Mr. Stone, can you unmute your device and state your name, please?
Jeremiah Lamont Stone.
Okay, and do you have discovery, Attorney Gagnick? Has discovery been provided?
It has been provided. I have it.
Okay, all right, anything else preliminary for exam date set? Actually, I can't hear you that well, Attorney Gay.
Let me move around. Yes, please set a date.
Okay, so the date set here is for May 11th, does that work?
No, I'm in a trial across the street.
What's your next available day?
I could probably do Monday. Or, Monday or Tuesday of the following week.
I'll do the 15th.
15th, I'll take it.
Can you do 9 o'clock?
Yeah.
Okay. Mr. Stone, your exam has been set for an in-person preliminary examination, May 15th at 9 o'clock a.m. at 36th District Court. Understand that?
Yes, ma'am.
Okay, anything else from either party?
Well, thanks.
All right, have a good weekend. You're all set, Mr. Stone.
All right, you too.
Thank you. Okay, and for Mr. Demetrius Johnson?
Yes, Your Honor.
Okay, he's not on now, but he was logged on, correct? Attorney Gagnon, did you say your client was logged on, Mr. Johnson?
No, I haven't had I don't have a good phone number for him.
Okay.
It looked like, I thought I saw that someone else had retained in the matter, and I wasn't sure.
We don't have any type of notice. There's nothing in the file that says he retained counsel.
You wish me to check back in? I'm just running around circuit court right now, or I'll do whatever the court feels.
Let me make sure here, there's no appearance. Yeah, just check back in, we'll see.
Thank you.
You figure that out.
Do you want my phone number just in case?
That'd be great. What is it?
248-259-4381.
Okay, thank you.
Thank you.
Attorney McCoy,
Yes,
good morning.
good morning.
Who are you here for today?
Demetrius French, case number 23056361601.
Okay, I didn't have you on the docket today. We are not letting in people who are not identified on the docket for certain reasons, because people keep showing up that aren't supposed to be here. So I didn't know which case you were on. So let me. This is the people of state of Michigan versus Demetrius French, 2356316. Mr. French is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons carrying concealed. Count 4, weapons, funding firearms, second offense. Count 5, weapons, funding firearms, second offense with habitual offender, third offense. Notice set for a probable cause conference appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
Alan McCoy, P38666, appearing for the defendant.
And Attorney McCoy, do you have discovery?
Was that? I didn't hear you, Judge.
You have discovery on this case?
I just got it last night. And I didn't get the body cam if there is any or anything like that, Your Honor. I would ask for more time to get ready.
Mr. Sawaki, do you have any information on when discovery was provided?
Paper was provided in 427, and I sent what digital we had last night. But we have a different attorney, so.
Okay.
So Mr. McCoy, what's your P number?
P38666.
My colleague is going to be sending you that stuff to you directly.
You're not clear, Your Honor.
The prosecutor is going to send a discovery to you. We had a different attorney assigned, so you didn't receive everything.
Right.
So let's come back on the 10th and make sure you have everything, and we'll set an exam date at that point.
I don't think the 10th's a good, I think he's got something else going on the 10th, Your Honor.
Okay, well, how much time do you need to send out the discovery? I can have it today. Can you come back tomorrow to make sure you confirm you have discovery?
I've got the
Monday, excuse me.
Monday, okay, Monday. What is that? 8th? Yeah, I can come back, Your Honor. I'll try to get through everything and see what's going on.
Okay. So, Mr.
Thank
French,
you.
on the 8th at 8:30, just like you did today on Zoom, and we're going to discuss discovery and move from there.
Thank you, Your Honor.
You're welcome. Anything else from either party?
No, Your Honor.
All right, have a good weekend. Okay.
Got it.
Okay, you know what? I'm so technologically illiterate. I'm trying to figure out how to get my name on here.
It's okay, Mr. Washington. I have you in the main room. They know how to do it. Third circuit. Attorney Washington, good morning. You're on mute.
Yes, good morning, Your Honor.
Your client is in person. He made some statements about wanting to represent himself.
Okay. I don't know whether I have let me see if I have the right phone number for him, and I'll see if I can call him.
Okay. Or do you want me to bring him in and he can give you a number?
Yes, you can do that.
That's you. I'd rather-
Gotcha.
Yep. Councilwoman file back to the coach. Who's Mr. Washington? Mr. Washington, he's on Mr. McCreary. McCreary? Yeah. We have Attorney Washington. He's saying that he's your attorney. And I know you said there was a, or repeated back to me that you don't want an attorney, is that correct?
Excuse me, I would first like to represent myself and reserve my rights under MCL 440.
One question at a time, one statement at a time. You wish to have an attorney?
No.
So Attorney Washington.
Yes.
Okay, can you be on standby and just?
Yes, I can be on.
Okay. Have you had any conversation with Attorney Washington yet? No? Okay. All right, give me a minute. You can have a seat. I'm gonna fight it. All right. Thank you. On Jalen Welch, the last PCC. If you finish attorney design that you got to know what to show them. Yeah, he's a go getter. You ready on the carry? This is case 2356485, the people of State of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm less than murder or by strangulation, count 3, weapons, firearms possession by a felon, count 4, weapons, ammunition possession by a felon, count 5, assault with dangerous weapons, loaded to assault, count 6, 7, 8, 9, 10, all weapons, only firearms. Individual could report the offense notice set for a probable cause conference appearances.
Ellen Milwaukee, P54828, we have people.
And I'll just state my name for the record, Earl Washington, Neighborhood Defender Service. And I'll just say on behalf of Mr. McCreary.
Okay, Mr. McCreary, we will establish that he is not your attorney, okay? You state your name for the record, please.
First, I'd like to reserve my rights under MCL 440.1308 UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, intentionally. I respectfully compel this honorable court to utilize Article 3, Section 2, Clause 1 of the U.S. Constitution, which mandates the common law to hear this matter. Also, under UCC 1-103.6, the name in all caps is a corporation, fictitious person. I would like to make arguments of personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. I have all federal questions that I would like to present to this court, and I would like this matter to be ruled on under the federal law of U.S. Supremacy Clause of Marbury versus Madison, 5 U.S. 137-18-3. Which says anything repugnant to the United States Constitution.
I just need your name.
Well, ma'am, I do not choose to end my name. I'm not the all caps on the paper. And I reserve my rights.
You don't have a name, so you're not present.
Well, my name is Colonel Michael McCreary, ill, all lowercase.
Okay, that's
The
fine.
all caps represent.
Okay, all lowercase. Is that your name?
Yes. but I
Okay,
reserve
you're
my rights.
physically present. Thank you.
Yes.
That's all I wanted to know, that you were
Okay.
here.
Yes, ma'am.
Okay. So Mr. McCreary, in all lowercase letters, is it correct that you do not wish to have an attorney present for the meeting?
And myself, which under Michigan,
Yes or no?
I'm no attorney.
Okay. You understand you have a right to an attorney?
Pardon?
You understand you have a right to an
I
attorney?
understand.
Okay. You gotta take this club, because I know you have a lot you want to get out.
Yes, ma'am.
I'm very familiar with all of your case law and your argument. However, moving forward, it needs to be in writing to submit to this court before I can rule you.
Well, I understand. Respond, please. Thank you, Your Honor.
Without
yes.
arguing with you.
No, ma'am. I'm very humble.
Procedurally.
I'm very humble. Well, I'm entitled to procedural and substantive due process. The statutes in which the state are charging me with are null and void in violation of the U.S. Constitution, the Shaney versus Winnebago Department of Social
That's
Service.
substantive, stuff that needs to be right.
Pardon?
That's the substantive.
Well, I've
stuff that
always
needs to be
learned as being a layman in the law, but I am.
You're not a layman in the law.
I'm a legal practitioner, not licensed under.
You're not a
corporate-
layman, you just don't have a P number or license.
Well, that's a corporate bar number, which is a corporate monopoly. They have tried to take over the legal system for their own benefit.
Well, that's an argument.
And once jurisdiction is challenged, it must be proven by the people exerting that.
But I can't address it until you put it in writing.
Okay,
That's what I'm telling
yes, ma'am.
Okay.
Well, I just want to note for the record that I did challenge personal jurisdiction must be done on onset. There's a case from the Michigan Supreme Court.
you. It needs to be in writing.
Okay, can I just.
You're dumping all this stuff. And you
Yeah, I'm just
expect
for
me to respond.
preservation, because I've been wronged by Kim Worthy, DPD. They have committed crimes and there's evidence of this. Also, I'd like to change the venue from the prosecutor's office because of criminal misconduct is well documented. The gentleman on this case, who was my brother, he's speaking of, he's committed.
I
felonies.
don't want to know about anything substantive on this case. But I will move this to another court the moment you say something about allegations.
Okay.
Gladly.
All due respect, but I was just trying to, I respect the court.
I understand you have a lot to say.
Yes, ma'am.
You understand it needs to be a right.
Yes, ma'am.
Okay. Are you familiar with the court rules?
Yes, ma'am.
Okay. So you submit it to the court and to the prosecutor, whether you think there's jurisdiction or not, you still have to submit it so that I can address it.
Yes,
Okay?
ma'am. I understand.
Okay, so are you familiar with this court's criminal procedure as far as why we are here today?
Yes.
It's called a
I'm familiar with the
probable cause
ministry.
conference.
Yes, ma'am.
Okay, so typically what happens next is we discuss discovery and the allegations that would be in writing, and paper, police report, and any video. You understand that?
Yes.
Okay. The prosecutor is obligated to provide that to you. So regardless if you think this case should be thrown out, the prosecutor still needs to do his duty and provide that to you. So I'm going to ask the prosecutor to provide that to you. What I want from you is your motion in writing to the court and to the prosecutor, so that I can make a decision. You understand?
Yes, ma'am.
You have a question?
Question, if I may just ask for additional discovery of, in CR 6.201, there's rules as well as Michigan Supreme Court People versus Stanaway, which deals with additional discovery.
Do you even have any discovery?
No, I
Okay,
didn't
so
even know I had a court date. They
You
didn't tell
don't
me
even know it would
anything.
be additional, because you don't know what exists.
Well, what I'm saying is, I mean, so far as stuff that I would like to be brought forward concerning the prosecutor's office.
Absolutely, let's get over what they have, and then you can make a discovery request.
Yes, ma'am.
But before that, you have to talk about venue, because you're not saying the right venue, jurisdiction, all the things. But the prosecutor's still going to provide you with discovery. So you need to look at that and see what it is that you have, and then you can request additional discovery, and then that you don't think that's sufficient.
Well, I mean, things outside, excuse me, department, not things concerning this case, but I mean, other things that has mattered concerning the alleged plaintiff, who also claims to be a sovereign citizen, my brother, and I need stuff from Judge Burton's courtroom. Things that
Alleged defendant or plaintiff?
Well, I mean, the alleged plaintiff, I'm sorry.
The complaining witness?
Yes.
Okay.
Yes,
Okay.
I mean,
So,
I haven't
do you
saw
have
my
an email
brother.
address?
Yes, I do.
Okay, don't provide it on YouTube. Do not say it. I want the prosecutor to receive that from you so that he can see your discovery. First step.
Also, Mayor, I asked a question regarding what you just said about YouTube.
Yes.
I know, under the First Amendment, we have a right to, record in public buildings, and also I would like to challenge.
Is it a right?
Yes, it's constitutional right under the First Amendment.
Okay,
enforced
no
by the state,
exceptions?
Enforced upon the state, Bill 14.
Are you familiar with the exceptions?
Well, the federal law doesn't say it's an exception.
Does it? It doesn't say any exception.
No, it's a right, because you go to Macomb County, they have.
Just because Macomb County doesn't mean that there's no exception in the First Amendment.
Okay, I just wanted to address that. For the
Okay.
record. I don't mean to be rude.
I know you're being very respectful, but you have a lot to say. And I want you to put it all in writing.
Also,
I want you to provide your email address to the prosecutor.
Yes,
Do that first.
yes, ma'am. If I also may state that,
Let's do one thing at a
okay,
time.
yes.
Your agenda is very long.
Yes.
Okay, so for the record, you have provided your email address to the prosecutor, is that right?
Yes.
Okay, so the next thing is, I want you to submit your motion in writing, okay?
That's now that you spoke about, being that, representing myself appropriately signed up under.
My choice.
Yes, under Michigan Constitution of 1963, Article 113. When it concerns talent, I'm on home confinement. I need to go to the law library. I need to work to pay bills. I'm not a threat to society. I let the officers in. The officers even stated that, what would I want to say? They even stated that, hey, you were very professional, et cetera, et cetera. Also at the other arraignment, the prosecutor spoke on my criminal record as a means of holding me in incarceration under People versus Allen. They cannot use your record against you unless you testify. And I have that citation from the Michigan Supreme Court. They have acted misconduct, ab initio from the very beginning at this junction, this case at bar. I'm requesting that, you know, I'm not a runner. I don't have rap in my blood. I'm not a threat to the alleged plaintiff witness. He doesn't even live in Manhattan. And, you know, the thing is, I also have another matter where the prosecutor's office came and arrested me for a 21-year-old warrant, and there's a statute of limitations for 6 years. Also, when I went to prison, there was 180 days. Now, the law says where the prosecution.
I know what the law says.
Oh,
But what I
please
want
make
you
this
to
point,
do-
man, under the rest.
I need you, it's not arrest.
Well, I'm
You're
getting
not
put in,
under
I'm
duress
here
right
by
now.
special appearance. I'm
I need
under
you to
duress.
step by step, just follow what I'm trying to tell you here. You need to educate me on some things so that I can make a decision. Because some of this stuff, you're citing UCC, and I'm very familiar with UCC.
And the
That's where-
Boston
and
Supreme
you cannot talk over me one at a time. I let you run off all your case law. UCC is for tangible, movable goods, not human beings. So, there you go,
Well,
write it, put it down in writing with all the things that you want to discuss. Because I can't stand here and listen to your oral argument. And
Oh,
you
no,
just
it's not.
cite cases.
It's-
We have 500-600 examples to hold. And
Well,
I'm
I'm
giving you,
following. I'm sorry, and I was just following the way that I was
you still
mandated
talk.
by court rules.
I'm just trying to preserve the record right now and inform you. So I asked for you to provide your email address. The next thing I want you to do is provide your motion to write.
Okay.
So I'm going to give you a date to come back. Okay, so you can make your argument.
Yes, ma'am.
The prosecutor will have an opportunity to respond. However they want to, or according to the court rules, as you say. So I will have you back here, today's the 5th. I want you back here on May 9th. Okay, that's the first thing. You will will address bond, okay?
Yes, ma'am.
So May 19th. In time. You come at 8:30?
Oh, yeah, I got up this morning, so I didn't even know, I came down here just a goodwill, so I was caught up, with cases. And that's what I was trying to address, if I was
Yes.
also go
You'll
work.
be here at 8:30.
Yes,
on
ma'am,
May
yes,
19th.
ma'am.
Okay.
And that's what I was saying, if I go to law library.
Okay,
to work.
let me court date first, then fine. Mrs. Long, do everything?
Yeah,
Oh, we won't be here. We'll be in training. That's why
Oh.
there's nothing on the calendar. I want a day where it's not. So let's do, May 22nd. That's not a good day. I won't be here. Can you do May 24th?
Oh, yeah, I'm on your, hear about the rest, man, force and coercion. So I have to comply with the court's order until we can litigate this,
What you want to comply with?
oh, no, I have to do what the law tells me. Because I'm under threat of force and coercion.
Hold on, don't start talking yet. Let me break it down. So May 24th at 8:30 is the date, okay?
is that PCC?
Motion here.
Motion here, okay, thank you.
And I'm going to provide you with the email address for you to send the motions to the prosecutor and to the court, okay? And I have to send, please do not send anything in mail.
See, that's the thing, I was, need access to, like, let's say,
Okay.
go somewhere and type up
We'll get
stuff to
that.
be able
We'll
to
get to
learn
that.
how to scan.
Get to that. Okay? And we'll have the court email address and the prosecutor's email address on their report.
May I speak with the prosecutors, being that I'm co-counsel, I would like to speak with them maybe about potential, contractual offer agreement. So we can
Co-counsel?
rectify. I'm counsel, and he's the counsel, that's what I'm saying, I'm not considered a defendant to where if I was, being
You represent
represented by.
yourself, you already wrong.
Yeah, I would be able to talk, him or her, or whomever's in charge. Yes, ma'am.
And just so you know, Attorney Washington is on standby.
Okay.
In the event that you ever request an attorney, he is well apprised and knows what's going on. That's what he's here.
Yes, ma'am.
This is a constitutional right, you have an attorney, you know. He's not gonna say anything unless unless you request that you need an attorney, okay?
Oh, no, I'm fully, versed in the law from A to Z, and I know the system's in and out.
Good, that's
Yes, ma'am.
wonderful.
If I may, address the fact of speaking with the prosecutor, because we save a lot of money. I don't have a problem with the state, but what my question is, take me under Michigan rules of professional conduct. 318.
All right, so now the bond, you are on house arrest,
Yeah, I'm on time. They say that I can't.
tether or house arrest?
House arrest.
I don't have your,
10,000, 10%, with tether, no house. I mean, I can't leave the house. And, I'm trying to be able to move to go.
let me
to
print it out and read, because I can't go. I can't listen to you. I have. Okay, thank you. Prosecutor and the court.
Oh.
Yeah, the report. Thank you. All right. Right, you said 10,000, 10%. So you posted it and it says here, GPS tether requirement, house arrest allowed for travel, court, medical. Do you have a specific library that you go to?
I know it was one on Oakland, but I don't know. I haven't been there in years, like by Landwood and Oakland, because I stay over here on next to the thing here at home. Yes, I could probably go to that. That's the closest one. I don't know. Is it one down here, like downtown, like the library? I can.
The main library.
Okay, I would, if it's okay for me to come down here, I could let my tether person know.
Well, I'm gonna let them know. That's what I want you to
Yes,
tell
ma'am.
me.
Yeah, the main library now.
Okay.
And,
I'll change your bond condition so you're allowed to go to the library.
and also, I'm a private contractor doing 1099 work. There's a Jerome Phillips Plumbing. I work with him from time to time. And then across the street from my house, there's a Robert Vane Diner. He posted my bond. He's a Russian immigrant. I work for him. He pays me. I pay taxes and bills. So 1099. I would like to see if I can work with you guys so I can pay my bond, tether, bill, my home, be able to go to the grocery market and get food, you know, and I would comply with the court's order. I haven't been in trouble over 20 years, and these charges are ridiculous. And I asked the court humbly to allow this so that I may receive justice for federal constitutional kind of law.
Well, you have a responsibility. I granted just to allow him to go to the library.
Yeah, yeah, Your Honor, we have a problem with that. I mean, these are multiple weapons charges, possession by a felon, assault, murder.
Objection, Your Honor.
We-
You
it's not
wouldn't let me speak about the facts of the case.
I can't hear his argument unless he's
Okay.
not interrupted. I'll let you respond.
We object.
I object to, because if you speak about stuff, I have a right, just being impartial on the Code of Judicial Conduct, County 1, that the judiciary is for the benefit of the litigants, not the judiciary. Code of Judicial County 2B, the court must adhere to Constitution and use equal protection and equal treatment in this matter. And again, since he's making an argument, I challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction must be proven by the prosecutor. These allegations under Opera versus United States are hearsay. You must have cooperative evidence. At this moment, I would like to file a Michigan habeas corpus under MCL 3.303. And I
File that as well with the rest of your motion.
Pardon?
File that with the rest of your motion.
Okay, but my point is, if he's making an argument, I have the right under due process of the 14th Amendment procedural, the statute due process and the 14th Amendment to the same arguments and things of this nature. Under 3.8, this prosecutors was acting in misconduct.
3.8 what?
Pardon?
3.8 of what?
The Michigan Rules of Professional Conduct issued down by the Supreme Court of the State of Michigan. He has a duty to ensure that the defendant has a fair trial, that justice is based on evidence, not speculation or whatever else. And then he's remaining silent the whole time. There's a tacit agreement by him remaining silent. There he's equating everything that I'm saying is being true. He has to rebut that once the jurisdiction
For a bond
is
hearing?
brought. Pardon?
For a bond hearing.
No, I'm just saying
That's what, we're addressing bond.
well, he's speaking about allegations of the case.
But that's
And
part
I'm
of the bond
defending
hearing.
myself
Part of the
against
bond hearing. So.
But he can't
Mr.
mention
Milwaukee,
that.
my question to you is, do you have enough time if motions are submitted by the 19th to respond on
Said
the
24th.
24th? Or do you want more time?
I like a little bit more time.
Okay,
Well, see, we can settle this all if you let me speak.
no, I'm not doing this thing with you. I need something to write. You're throwing out rules from all of.
No, I'm not saying so far as litigation, but I'm saying the county, I don't have a problem with the county corporation, state corporation. This is the person that they're working with is a criminal. He has a record, like Kim Worthy made a list saying that police officers can't testify in court. So to allow my brother to testify in
You're
court,
still
that's.
arguing the subject matter that I need you to.
Okay.
I need to have it submitted by May 12th to the court and to the prosecutor.
But I need time to, like I say, get to these places to, you know, I need, you know, computers to be able
I'm
to.
filling out your
Yes.
motion right now to adjust bond so that
And
you can go to
food.
the library.
I need to go to the market, work, you know, I thank you, Judge, for being humble. Can we get this transcribed for the motion hearing?
Wait a second, I'm trying to write notes. I want to be very clear about what's going on.
And where can I find this tape on YouTube? I'm sorry, ma'am, I'm just anxious because I have done. I stay upstairs by myself. I have tenants downstairs presently at this moment because I'm trying to pay my taxes and maintain my money to stay.
So, Mr. Curry, I know that you were objecting to the prosecutor's response to the bond adjustment, excuse me. library. And as far as everything else at this point, I'm not gonna adjust bond. Okay, are you familiar with?
I'm not
Yes or
really,
no?
no, ma'am, I'm not, I'm not really computer literate.
You don't have to be, you can do all these motions.
Well, I'm gonna have to learn.
Yes.
You tell me.
Okay, so your motions are due.
Can I also ask you one
Email.
more?
Hold on,
sir. Oh, I'm sorry.
May 12 via email. You have both email addresses. You have them for the court and for the prosecutor.
You said the 12th, I thought you said the 24th.
For the court, we're gonna hear them. The
Oh,
prosecutor
so
has to have
get them
time
in
to
by the
respond.
12th.
You don't have to be here on the 12th, it just has to be emailed.
So do I have to show up back here at that date or?
On the 24th.
On the 20th, okay.
But the 12th, just email it so that I can read it, the prosecutor can read it, prosecutor can respond, on the 24th, you can go. Okay. First case, nobody be in front of us, I can make a decision, we go from there. Okay? All right.
Can I ask you one thing before you close? the
One
record?
thing?
I mean, yes, ma'am, if I
What is
may.
it?
I have DTE bills, phone bills, and it's just right across the street. Like I helped my neighbor fix his house at the home. And I just want to make a few dollars so I can pay the bond people in court. That there's anything that needs to be, my bills. That's all I'm asking. Just right across the street.
What's the address?
I think it's, well, I'm 14739 home. It's directly across the street. I think it's 14754.
147.
I believe it's 147. My address?
No, the address.
I believe it's 14754, but I can email or I can tell my teller the correct action.
See, you tell them, you don't tell me.
Well, I've heard that they communicate with you. So,
I got it, okay.
okay, if you give me a number, I can send it to you or email it to you.
Street?
Homer, HOLMUR. It's right on.
I'll allow you to go across the street, make some money to pay each other, and provide food for yourself, whoever you need to get back to the court, okay?
And thank you, ma'am,
You're
for
welcome.
your being patient.
No problem. All right. Thanks.
Excuse me, Your Honor, this is Earl Washington again. Did the court wish me to be there on the 24th as a standby?
Yes, please.
Can I get his number? I call
Sure.
him. Yeah, and see, maybe he can help me, but like if I can email him, he could probably type it up. That's all I would need his help for. No disrespect to you, Esquire. But, yes, sir.
You provide your number to Mr. McCreary, right?
Yes. McCreary E. It is E, capital E-L.
Not L.
It's pronounced L, but it sounds like E. It's E-L, yes, sir.
You want me to put that in the chat?
You can just provide it over, is it your personal cell or your work cell?
No, it's a work cell. My name is Earl Washington, and the number is 313-418-8692.
Oh, thank you, sir.
Okay, we're done on Mr. McCreary L.
All right, thank you. Have a good day and have a good weekend.
Thank you. Too.
So I need an OIC. Is that yours?
Is there a time, Judge?
8:30.
8:30 for when?
For the 24th?
No, I'm saying for me to be able to go downtown to like here. Like.
Library, whatever.
Oh, okay, yeah, I didn't know, because they was telling me strict is strict, but I'm telling I only get like.
The library. 10.
Okay, so as long as it's going there, I'm okay. You said it's down here at Main. Okay, thank you.
And this is what is. They told me when I tried to get us. It's our. I got you. Thank you.
Attorney Cho, good morning.
Good morning, Your Honor.
How are you doing today?
I am good. How are you doing?
Good. Let's call your Mr. Welch, right?
Yes, Mr. Welch.
She wants Spofford, right?
I'm sorry, it could be Mark Brown.
Yeah,
Okay.
it's Mark.
I'm sorry. Here.
All right, this is people versus Jalen Welch, who is defendant number 2 on case 2356601, charged with count 4 conspiracy to commit stolen property, receiving and selling motor vehicle. Count 5 stolen property, receiving and selling motor vehicle. And that's it, that for a probable cause conference for appearances.
Your Honor, Danielle Parrish standing in, I don't believe this is our general exams case, standing with people, P8495.
Good morning, Your Honor. Alexandra Choate with the Neighborhood Defender Service of Detroit, P85948, appearing on behalf of Mr. Welch. Your Honor, I believe Mr. Welch is not present in court. I have spoken with his father. The number that we were given is his father's number. He's currently in the process of, I believe that Mr. Welch was recently in the hospital and had lost his phone. I would just request a couple weeks adjournment in order to get in contact with Mr. Welch himself.
Your Honor, no objections for an adjournment, just because, again, we are not the actual case, it's a tattoo case. So it'll give us an opportunity also to send the update to the APA case.
You know what, I'm gonna allow for it because the co-defendant is actually being referred for competency as well. So I will adjourn this to May 25th. By that time, you should be able to find the client.
Yes, and his father believes that he should be able to get in contact with him relatively soon.
Okay. All right.
Thank you, Your Honor.
You're welcome. Have a good day.
Yep, have a good weekend as well. Bye.
Okay, Attorney Gaddis. Your client is not present for the call of the case. People of the State of Michigan versus Demetrius Dean Johnson, case 2355995. Mr. Johnson is defendant number 3 and charged with count 1 stolen property, receiving and concealing $20,000 or more. That's it. Set for a probable cause conference comparison.
Good morning, Your Honor, Danielle Parrish on behalf of the legal P85495.
Brian Gagnon, Your Honor, Neighborhood Defense Service, P64220.
And your client is not present. Have you been in contact with him at all?
No, I have not, Your Honor.
Anything for the people?
Your Honor, people would ask for a case.
I'll leave it in the court's discretion.
He said he will leave it to the court's discretion. Okay, so he does not have any capious history from my understanding here in the ROA, so it'll be a $1,000 personal fine. It will be a capious.
Thank you.
You're welcome. Have a good weekend. Yes, we're done. Hour and a half. Oh, what else we got? Who is handling this Roosevelt Evans motion? Ms. Parrish, I'm sorry, are you handling this, the Evans, Roosevelt Evans motion?
Is that the one that Kirker? No, APA Kirker is handling that.
Scheduled for today. Is he here tomorrow? Monday?
Yes.
Okay, Mr. Sulaka, I don't know how this happened. Mr. Kirker is not assigned today to the courtroom.
I had mentioned that to him. I think he was trying to get it resolved prior to today, but I don't know what ended up happening. I've been out the last 2 days, sorry.
Okay, let's see. Attorney Sulaka, can you hear us?
Yeah, let me, yes, Your Honor.
Mr. Kirker isn't assigned today to the courtroom. Did you know that? Because
I have not, I'm checking to see whether or not I had any communication on that. No, I did not. The last communique that I received, Your Honor, was in regards to the 180-day into which I replied that I'd be withdrawing the 180, the motion on 180-day rule. But the motion on the due process and right to a speedy trial would proceed. But I was not informed that the APA would not be here today.
Okay, I received that email from you as well. Mr. Kirk will be here Monday. Attorney Swag, I do want Mr. Kirker here because he's very aware. Ms. Perry, I don't think she's briefed on the issue. Can you come back Monday for this hearing? Or Tuesday?
No, I want to get this resolved for my client as quickly as possible. What time Monday, Your Honor? I'm sorry, what time Monday?
Our first exam is at 9 o'clock. So,
I will, let me see here real quick. I think that should be, we're looking at Monday, the 8th, right? This upcoming Monday?
yes.
Yeah, that will be fine. I do want to, are we on the record or no?
No, let me call.
Okay, all right. So there's just a housekeeping minute. All right, so we're going to move this to,
You need to go on the record?
the 8th at 9 a.m. I think it's fine as long as we can coordinate and somehow inform my client because he was not here on the Zoom hearing, so I'd like to make sure that he understands what's going on here.
Okay, I'll have, so it says here that he's out on a personal bond and he was released, but that's not your understanding, correct?
I spoke to him. Yeah, he's definitely not released on bond. You had issued a personal bond, but he can't be released because of this case. So he's eligible for parole. They will not release him with a pending felony charge against him.
Okay, he's at STS.
Correct.
All right, we'll make sure he has a Zoom writ for Monday at 9 o'clock.
Okay, thank you, Your Honor.
Okay, and I'll send an email to Mr. Kirker as soon as we get off the record.
Thank you.
Have a good weekend.
Thank you. You as well, Your Honor.
So Foster's not, Foster's attorney
You need some water?
Attorney Sullivan. I know, it's coming up. I was telling you to. Yes, ma'am. Sure, absolutely.
Good morning, Judge. How are you? I'm well, thank you. I just wanted to check that necessary officers are here before I. Okay. That's kind of, I figured it'd be easier. So yes, Judge, it would be.
Okay.
I practice.
Yeah, right.
I would always put it, you know, down to sleep.
Mr. Sullivan. Review your plan and then we'll get-
Thank you, Your Honor.
Thank you, Judge.
Because you support the town. So before we said to the state of my agreements, like, as long as I have your P number, like, it's already in. So all we do is like, take you guys need to just go to the judge. As long as I have it.
That's great.
Yeah,
Yeah.
that's good.
Right.
Right. Okay, we are on the record. This is people of Michigan versus Kobe Raekwon Boyles, case 2355721. Mr. Boyles is charged with count 1, motor vehicle unlawful driving away. Count 2, attempted motor vehicle unlawful driving away. Count 3, assault with a dangerous weapon, felonious assault. Count 4, police officer fleeing, 3rd-degree penal code. Count 5, malicious destruction of fire or police property. Count 6, police officer assaulting, resisting, and obstructing set for preliminary examination state appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P 85495.
Good morning, Judge. Neighborhood Defender Service by Ian Sullivan, P 84261. Here representing Kobe Boyles, who's present here in the courtroom. Mr. Boyles, please just state your name to the judge. Yeah, Kobe Boyles.
Good morning. Okay, I have a waiver form before me. Is it correct your client's on waiver to exam today?
That's right, Judge. I have advised Mr. Boyles of his absolute right to a preliminary exam. We've discussed his options. It's his decision today to waive that right to a preliminary exam, allow the case to move forward to certain court.
Is that correct, Mr. Boyles?
Yes, Your Honor.
Any objection from the people?
No objections. Yeah.
I'm going to ask a couple of extra questions, okay, Mr. Boyles?
Yes, Your Honor.
As you understand this, you're right, as your attorney just discussed, correct?
Yes, Your Honor.
That if you were to demand that exam today, The people will have to prove at the probable cause standard, which is a much lower standard in criminal law than the standard. That all of those charges I read off were committed in the city of Detroit, and that you probably committed those crimes. You understand that?
Yes, ma'am.
And that by waiving your exam today, that means that people do not have to prove anything at that standard today. Understand?
Yes, ma'am.
You also understand that you're not giving up your right to trial.
Yes, ma'am.
Did anyone force you or threaten you to waive your exam?
No, ma'am.
Did anyone promise you anything?
No, ma'am.
I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Framework of Justice for the arraignment on information 1 week from today. So that would be May 12th at 9:05 a.m. Okay? Anything else from the party?
Nothing additional, Judge. Thank you.
Okay, you're all set. Mr. Williams. Back to Mr. Ready on Ponder?
Ready, Your Honor. Your Honor, this is 8 days, so I'll please, I will have, do you want me to find out on that other one? I can try to read Mark around Mark. I'll go outside and grab the area here. Okay.
Ms. Ponder, you got this.
Yeah.
Mark Brown, right, Nancy, scrap.
Cool. Thank you,
Are
Danny.
you waiting on Carol Brown?
On 9:30. Which is here on the 9:30.
All I see is informed me that they refusing to appear to prosecute, so. Whatever he gets, we'll be able to handle it, but I don't, I'm not sure because. No, okay,
Scarborough.
okay.
Attorney Brown, good morning.
Good morning, Your Honor.
Your client on his way here?
As my understanding, he called me earlier and I called your courtroom. Unfortunately, he called while I was on another line, so I don't know the number he called from because he didn't have a phone before. He said that he had some difficulties with his car. He was getting on the bus. He was going to come down here. I called to find out whether or not the complaining witness was present because my understanding he might not have been present.
Defense counsel, complaining witness is not here. The officer in charge did come in their place and have indicated the communication that they had with the complaining witness. They are, at this time, the OIC has indicated that the complaining witness is fearful and is refusing to come in to testify. So at this time, we cannot proceed, but obviously we need your defendant here to handle the case.
It's my understanding that he's on his way, so could I zoom back in because I actually need to be in another courtroom momentarily?
Yes, can you provide your number so we can
Certainly.
call you?
Certainly. Can I give it to you now? Clerk, Madam Clerk. My number is 313-999-0150.
Okay, I have it.
Thank you very much.
You're welcome. Okay, now, back to this. Sister Walker, are you ready? I'm responding. people of the state of Michigan versus Janelle Ponder, 2356345. Ms. Ponder is charged with 1 count of robbery armed, set for a preliminary examination today. Appearances.
Edwin Sawaki, P5488, appearing on behalf of the people.
Good morning, Your Honor. Sharon Payne, P38749, appearing on behalf of Ms. Pounder, who is present in the courtroom today. We are ready to proceed to exam. We would ask if the prosecution has more than 1 witness, there be a sequestration order placed in effect, and we have no objection to it being neutral.
Okay. Ms. Ponder, can you state your name for the record, please?
Janelle Nicole Ponder.
And if there's anyone on YouTube or on Zoom who is watching who may be a potential witness, now's your time to log off. On this case, it would be an OIC present for request.
There will be an OIC present in the courtroom, or she will not be testifying.
Any objection to the OIC?
No, Your Honor.
Okay. And for the record, there's no one else present other than staff, attorney, and Ms. Ponder. Any other preliminary matters before we begin?
Not from the people.
No, Your Honor.
Okay, call your first witness.
People call Rosa. Probably mispronouncing.
The victim advocate?
Yes, Your Honor.
Okay. Any objections to the victim advocate being in the courtroom as well during the exam? Attorney, is there any objection to the victim advocate being present in the courtroom?
P is a Paul, yeah. ACH.
Yeah.
No, no. That's it. Okay, that's it.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Okay. You can have a seat, the door pulled open in the front here. And the microphone, you can put in your lap, if it's easier on the right side. And Madam Court Reporter, while you were getting a name, there was no objection to the victim advocate being in the courtroom from the defense counsel. And whenever you're ready, Mrs. Swan.
You just give your full name for the record, please.
Rosa Pacheco.
And what brings you here today?
I was selling Easter baskets, and this young lady stole $75 out of my cash app.
Michael, can you speak up just a little bit for us, or adjust the microphone?
Can you hear me now?
Yes, thank you. And did that incident occur on April 8th, 2023?
Yeah.
And did that occur around 1000 East 8 Mile Road? Correct. That's on the south side of 8 Mile?
Yeah.
And that's in the city of Detroit, California, correct?
Correct.
And what were you doing? What were you doing at that location?
I was selling Easter baskets in the parking lot of Norman Mills, right on 8 Mile.
Were you approached by an individual?
Correct,
Objection,
yes.
Your Honor, he's leaving. Just suspended there. As far as the preliminary matters, date, time, location, I allow that. But now we're getting to the actual testimony. You have to be.
I understand.
Yeah.
At that location, what happened?
The young lady approached me. She was interested in some baskets. She picked 2 of them out. She said, "Do you accept Cash App?" I said, "Yes, I do."
Well, I mean, is that individual in the courtroom today?
Yes, sir.
Could you point her out and describe the piece of clothing?
She's right there in a green shirt.
Let the record reflect that the witness has identified the defendant.
So reflected.
Okay, what happened next?
I pulled my phone out to open the scan or
so we could scan each other's cash apps. And she said her scan wasn't working. And she started giving, I said, well, just give me your cash app name and I'll just punch it in. And she started like rambling, phone numbers, addresses, she pulled her bridge card out and gave it to me, and told me to scan this. She gave me, I think a state ID, asked me to scan that. I said, no, that's not how it works. And I said, well, ma'am, you just want to put it in my phone and put your own cash app name in there. So I passed her my phone. She's over there typing away, and passes me my phone back and said, never mind, it won't work. So when she passed my phone back to me, I literally immediately looked at it, and I seen that it was set, well, it was only $13 left in the account.
Let me ask you, how much? Oh. Yeah, did you have, why was only $13 significant?
Because I knew that was $88 in the account.
So what happened next?
I seen it. She had only walked very short. I seen it immediately. I walked back on the sidewalk and I said, hey, excuse me. You've made a mistake. You took 75 out of my account. You need to put it, into your account. She says, just reverse it. I didn't really know how to do that. So I literally held the phone to my side, because it was a very sunny day. I held the phone down like this to get in my shadow. And I was trying to, with my phone.
And we say like this, you describe.
Like I'm holding the phone like this, and I held it down to the side to, be in my shadow. And I was trying to figure out how to reverse it.
Let the record, reflect that the witness has held up her hand, right hand, sorry, and has moved it from around, her head down to her leg.
At that point, we were still very close to each other, like less than 5 feet from each other, arm distance. I was alerted for my friend that was also out there with me. She said, back up, Rosa, back up.
Objection, Your Honor, hearsay.
Please, accept.
No, Your Honor, just explain what you observed, not what anybody specifically said.
Okay. When I looked up, I seen she had a knife. I immediately put my phone in my pocket.
You said we looked up, saw what?
She had a knife. I immediately put my phone in my pocket, reached in my purse, and it was the same kind of purse, pulled my weapon from my purse, and immediately bagged up at least 10 to 12 to 15 feet. That put space between us.
Record should reflect that the witness is holding her hands in a manner that one would hold a pistol. See what happened next.
I said, I told the other young lady that was with me, call 911 right now. And she said, Janelle Connor said.
Okay, who's Janelle Connor? Oh, okay. Continue.
She said, I don't give a F, call the police, I will stick your ass. I held her, she never approached me, I will say that. She continued to walk very slowly, casually up 8 Mile, just kept walking. I held the gun like this. When she got where I was behind her. Sorry, I'm sorry.
We have to preserve the record. I can't see either, so I don't know what.
Okay.
If you could describe.
Okay, witness is, continuing to hold her hands, as if she's holding a pistol.
Did you have a pistol in your hand?
Yes, I did.
When you saw the knife, how did you feel?
Very scared, extremely scared, shocked. I knew I had to get control of the situation in some sort of way, so I knew to just back up and not be within an arm's length of the knife. I backed up, like I said, she walked casually up 8 Mile. As she walked and I was literally behind her, I lowered my weapon, threw it back in my purse, threw everything in the back of my truck that I had out.
The record should reflect that witness pantomime putting the gun back into the purse. Continue.
The back of my truck was open, so I literally just took everything, threw it in the back of my truck. I got on 8 Mile, I knew she had walked by the bus stop. So I got on 8 Mile, did a U-turn, and when I came where I thought she was there. She was at the bus stop. So I called 911. One 911 call had already been made. This is the second 911 call. So I called them again. I said, I just called a few minutes ago about a situation at Former Mills. I said, the girl is getting on the bus right now. Says, what bus, can you describe what she has on? I did so. The bus she got out of the bus stop and got on the bus. I told her she's getting on the bus and this is the bus number. And I gave them, it was 3840, the bus number. And the 911 operator advised me not to follow the bus, but I did. And I followed the bus up 8 Mile. And when we turned on Van Dyke, they transferred me to Warren Police.
Okay. The record should also reflect that the witness is indicating with her hands how
the bus
made turns. Okay. Continue.
As we were going, turning onto Van Dyke, the 911 operator transferred me to Warren Police. Warren Police just asked me what the bus number was again, what location, could I describe her, and was I, following the bus still? And I said yes. When we approached almost 10 Mile.
Ma'am, you said we, is there someone else in private?
No, I'm sorry. When I was on the phone with 911. When I got to about 10 Mile, she got off the bus right in front of PNC Bank. And I told the police officer, the 911 person, that that we were getting off at PNC Bank. She said, please describe her, what she has on again. At that point, I seen like 3 police officer trucks pulling up. And I said, she's right there in front of PNC, black jogging suit, white t-shirt, blue shoes, blue glasses, brown purse. So they arrested her at BP gas station.
Today, how do you feel about that?
Rejection, Your Honor, developments.
Your Honor, I want to know, I think it's important to know how she's feeling, whether she's, what her feelings is, she's still suffering from that incident. Or where she's still fighting or what?
Okay, so to prove this, only element that the defendant used force or violence, assaulted or put fear.
Okay. Well, then I have nothing further, Your Honor.
Thank you, Your Honor. Morning, it's Ms. Pacheco. Pacheco. My name is Sharon Payne. I'm an attorney and I represent this pounder, and I'm going to ask you some questions, okay? If at any time you do not understand my question, let me know. Thank you. So this happened on April 8th or April 9th?
April 8th.
And you were selling Easter baskets out of, I would assume, a truck at the Foreman Mills on 8 Mile in Detroit, correct?
Right.
And people were paying cash or they were paying with Cash App?
Correct.
And
Either
you-
or.
I'm sorry?
Either or.
Correct. And Cash App is an app you put on your iPhone, correct?
Or your Android.
On your phone.
Right.
And then somebody else has to have a Cash App in order to facilitate the transaction.
Correct.
And you testified that Ms. Pounder came up and wanted to buy a couple of Easter baskets from you, yes?
Correct.
And she was going to use the Cash App, yes?
Yes.
And there was a problem with her Cash App basically talking to your Cash App, correct?
She pulled bridge cards out for me to scan.
And you cannot use a bridge card.
Right.
Did at any point you see a Cash App on her phone?
I don't recall.
Did she not tell you her phone was dead?
No, she didn't.
Okay. And at some point you could not effectuate the transaction, correct?
Correct.
So she offered, or you offered, to let her use your phone to put her information in, correct?
Correct.
And when you got your phone back, you saw that there was money transferred from your Cash App, correct?
Correct.
And you confronted Ms. Pounder, correct?
Correct.
And she said to cancel, correct?
She said you can reverse it.
Reverse it, which would cancel the transaction, yes?
Yes.
And then at some point, after that, she was backing away from you, correct? She was away from you. You had your phone back, right?
At what point?
Before she said to cancel or reverse the transaction, she handed your phone back to you, correct?
She handed me my phone back long before that.
Okay, so she had your phone.
She had my phone and she told me it's not working. She handed me the phone back and she continued to walk
Away. And that's when you confronted her and said, hey, there was money taken out.
Transferred from my account to your account.
And she's walking away and she
No,
tells.
she was standing still at that point.
Okay, but she had been walking away, correct?
She had walked probably approximately 5 feet.
And she said then reverse it, correct?
So I did. I was still standing right there next to her and I was trying to reverse it.
Okay, so she told you to reverse the transaction.
Correct.
And then you said you couldn't, correct?
I was alerted that she had a knife on me.
That was
Before
not my question, was it, Ms. Mitchell? My question was, after she said to reverse it, she was done with the conversation.
Oh, she was still standing there,
Right.
waiting for me to reverse it. And then she pulled the knife.
Okay, so she was waiting for you to reverse it when you saw the knife.
Yes.
And immediately you pulled out your gun.
Immediately I backed up
And then
and pulled my weapon because she had a weapon.
So you pulled your weapon, your gun, out of your purse and you pointed it at Miss Pounder, correct?
Yes, I did.
And Miss Pounder did not come any closer to you, did she?
I backed up. I backed up 10 to 12 feet.
That was not my question. My question was after.
She did not lunge at me.
She did not come forward.
Because I put the space between us.
Ms. Pancho, listen to Pacheco, listen to my question, okay? After you pulled your gun and you pointed it at her, she did not come forward to you, correct?
No, she didn't.
Thank you. And at some point, while you still have the gun out pointing at Ms. Pancho, she starts walking down 8 Mile towards the bus stop, correct?
Correct. And I lowered my weapon.
And then you follow the bus to basically Macomb County, right?
Yes.
Thank you. No further questions.
No regret.
Okay.
You're all set, man. Sit down, you want her to wait in the hallway?
Yeah, she wants to wait in the hallway.
Any other witnesses?
No other witnesses, Your Honor.
Any witness or defense?
No witnesses, Your Honor.
Okay. In our,
Your Honor, people request that the court bind over the defendant on count one, robbery, armed, reserve argument.
Yes, Your Honor, we would object to the bind over. The people have not met their burden. To even satisfy a probable cause standard for armed robbery, there has to be some evidence that a weapon was used to commit a robbery. But in this case, they're alleging a knife. The incident between the complainant and my client took place before any weapons were produced. Additionally, after Ms. Pounder could not activate or use the Cash App, the complainant gave her her phone, and my client typed something, which was the testimony, gave the phone back to the complainant, and said, I couldn't, it's not working. The complainant said, you transferred money. My client immediately said to reverse it. The situation, the discussion was over. It was at that point that weapons were produced, not only by the defendant, but by the complainant, who had a knife, who had a gun to a knife. This does not satisfy the probable cause standard for armed robbery because there was no threat of a weapon to complete the act, in this case, a larceny. At the most, Your Honor, they have satisfied the standard for simple larceny. And that's questionable because Ms. Pounder said, reverse it. And she told, according to the complainant, she told her it's not working. So I believe this case should be dismissed because they have not satisfied the purpose.
Yeah, but Your Honor, people have satisfied the verdict. The money was taken when it was asked to be sent back before the transaction could be completed. The defendant pulled a knife. And so she scared the witness, the victim, to the point where she pulled out her own weapon in self-defense. And that's the knife and the robbery all took place at the same time. There was no one continuous action. The defendant did not pull the knife until she thought she was going to be, till after she was caught at doing the crime. And therefore, people have met their probable cause burden. It's a question of fact, and we ask that be found.
The court heard from Ms. Pacheco, stated that she was selling Easter basket, performing meals on 8 Mile, and the defendant encountered Ms. Pacheco and asked, or wanted 2 baskets, and asked if Ms. Pacheco used Cash App. And through testimony, Ms. Pacheco stated that she pulled her phone out for the scan, and said the scan wasn't working. Plaintiff witness asked for a Cash App name, and the plaintiff witness stated that the defendant began rambling and he gave bridge card to scan. And plaintiff witness gave the defendant her phone. Stated that never mind, Cash App didn't work. After the plaintiff witness got her phone back, she noticed only $13 was left in her Cash App account. And then she started off with $88 before she recounted the defendant. The plaintiff witness said to the defendant, you took $75 out of my account. The defendant said, just reverse it. The defendant or the plaintiff witness did not know how to reverse it. And at this time, the plaintiff witness and the defendant were very close to each other. And when the plaintiff witness looked up, she saw that the defendant had a knife in her hand. That's when the plaintiff witness pulled out a pistol out of her purse. And called 911. And the defendant said, quote, I don't give a fuck, call the police, I'll stick your ass, according to Mr. Pacheco's testimony. And the defendant began to walk very slowly at 8 Mile. So for this case here, I do believe people have been in the burden of proof. People have to show the probable cause standard. And first, the defendant used force or violence or assaulted or put in fear. The complainant witness in this case, I believe, put in fear forced and assaulted, and I'll get to that in a second. Secondly, that the defendant did so while she was in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money, in this case, money through cash out with the intent to take it away from that person permanently. That money was never returned. And it's to know that in the course of committing a larceny, it includes acts that occur in flight or attempted flight after the commission of the larceny, or an attempt to retain possession of the property or money, in this case, money. I do believe that in this case, the weapons began or were involved after the money was transferred, which still satisfies that second element. Third, that Ms. Pacheco was present while the defendant was in the course of committing the larceny. And fourth, that while in the course of committing the larceny, the defendant possessed a weapon designed to be dangerous and capable of causing death or serious injury in this case, as Ms. Pacheco described. So with that, I will have Ms. Ponder bound over to Third Circuit Court for the arraignment on the information. Since you're in custody, Ms. Ponder, to be 1 week exactly from today, so it'll be May 12th at 9:00 a.m. Anything else, Mr. Pardon?
Where will this be? I'm sorry.
Frank Martin College Justice, right across the street.
Oh, okay.
Yeah.
Sorry, I'm not familiar with the area.
That's fine. It's right across the street.
Your Honor, people would like to make sure that any bond condition, that there's a no contact.
Your Honor, the current bond does say no contact, and it's a tether. We would ask that the tether be modified to allow Ms. Ponder to travel to her attorney's office.
Okay, I will adjust it for that. Do people object, just for the record?
No.
Okay, so I will adjust that to allow for Ms. Ponder to visit her attorney and bring medical visits in the event that she's released. Okay.
Thank you, Your Honor. I didn't want to say.
Attorney Banks, can you provide the long time?
Oh, okay.
So we're not worried about
Yeah. I was gonna argue it.
Oh, And I know that, I said, let's go. She already here.
Okay.
It was an Austrian.
Evan. Evans it will be on Monday at 9.
So what do you have to do with Austrian?
Yeah.
Mr. Gold?
Yeah. He said he's flying cargo now.
Okay, now I remember.
You like, well, what did happen?
Yeah.
He said call this flying.
Okay. Then is it Bird Brown and Blackton as well? Or a different Brown?
Different route.
Of course.
It's gonna be on with Epps. With that, that's, I guess that's fine. Is the dismissal the 11 o'clock or the 9:30?
It's 11.
11 o'clock.
Walk.
Alright. How's the little lady? She's so fine. Almost walking. She's almost there. Oh, how old is she? 11 months. Well, she'll be 11 months on the 11th.
Oh, my goodness.
Yeah.
My youngest granddaughter is coming up in the fall.
Really? Yeah. That's great. Daycare, you know, she does everything everybody else does. She'll walk in daycare, but she won't walk. So they already said she's walking, but I haven't seen.
Watch your back.
Yeah,
I had to run.
It don't matter, it's up to you guys.
Where you talking
I
about?
don't care.
You trying to get it on the elevator? Come on now. Come on.
Ms. Blockman?
How you doing today?
Good, how are you?
I'm good.
You ready to go on the record?
Yeah.
Is this your case?
No, but
Okay. Okay. We're on the record, this is the people of the state of Michigan versus Sandra Shanice Blackton, 2356134. Ms. Blackton is charged with 1 count of weapons carrying concealed, set for a preliminary examination. Say appearances.
I went to walk with P548, on behalf of the people.
And Brian Brown, PA 0560, on behalf of Sandra Blackton, who is President of Blackton Police Station in Frederick.
Sandra Blockton.
Good morning. Good morning. Is everyone ready to proceed?
People are not, Your Honor, we are missing essential witness.
And, Your Honor, we would motion for dismissal.
Okay, the time is 11:02. People are not ready to move forward. Not move forward without an essential witness, so I will dismiss without prejudice. Cross the record. Fast.
That's how I like them.
Yeah. Okay. All right, here you go.
Wait, no, okay. Okay.
Attorney Brown? No. Attorney Brown, can you hear me?
Yes, ma'am.
Client still not here.
Contacting, he didn't have a telephone number before. Is my connection not?
I can barely hear you, but I understood you said you don't have his phone number.
No,
So
yes,
we
ma'am.
have, we're about to hold an exam, so I mean, until the docket's over, I'll wait. But I don't know what to do after we're done with the docket.
That's right.
I was just seeing if we could move the presenter along that's out there. I have a high priority appointment at 2 o'clock. I'm supposed to be at my daughter and son-in-law's fight and babysit my grandson.
High priority.
Yeah.
Absolutely.
All right. How you doing?
This guy. This one.
Okay, yeah.
Okay.
Down Jefferson. Still like it. Understand.
Yeah. Yeah, I get it. Yeah, thank you. Appreciate it.
Excuse me, Your Honor, we have Mr. Foster in the hallway.
Jeffrey Short.
Foster's in the hallway.
Moving back.
I'm sorry?
Foster's in the hallway. Oh, well, I mean, just for. Right.
Right here.
Stand right here in front of the yellow circle. Yeah, stand here, thank you.
No, I can look it up.
Okay. I had it, I don't know what it is. Oh, I just have it. Attorney Brown, this is just Sabree, your client's here.
Okay, thank you.
Foster, you have some car issues today?
Yes, ma'am. Yeah, I had called my attorney, Mr. Brown.
He told me,
Yes, ma'am.
we waited for you.
I wear hearing aids, am I?
I said we waited for you.
Yes,
You
ma'am.
still showed up.
Yes, ma'am.
You got it, Judge? Got it?
No? Okay, we're on the record as the people of the state of Michigan versus Bernard Foster, 2356142. Mr. Foster is charged with count 1, assault with intent to greatly bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault with the habitual offender forfeit. This notice set for a preliminary examination today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. I'm here on behalf of Mr. Foster, who's present in the courtroom, I understand.
Mr. Foster, state your full name.
Bernard Foster.
Thank you. Are the people ready to proceed today?
My apologies, Your Honor. The people are not able to proceed at this time. I spoke directly with the officer in charge of this case, who spoke with complaining and necessary witness on this matter, who at this time refuses to appear and to testify. Therefore, we are unable to proceed with prosecution.
I move to dismiss, Your Honor.
Okay, with that information, I will dismiss without prejudice. Mr. Foster, your case has been dismissed. You can wait in the hallway for your paperwork.
Yes, ma'am. Thank you. Thank you, Your Honor. Thank you, Judge. Go ahead.
Yes, sir. Thank you very much, Your Honor.
You're welcome. Have a good weekend.
You too.
Fine, no problem.
When I was dismissed without prejudice, you know why I was dismissed.
Yeah.
Blocking,
Because the necessary witnesses been shown.
Okay, so I see one now.
So.
Ready, I'm interested.
Absolutely.
Okay. Calling case 2356079. The people of the state of Michigan versus Kevin Jefferson, charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearms, set for a preliminary examination. Appearances.
Edwin Sabree, P5482, today, appearing on behalf of the people.
Good, still morning, Your Honor. Jeffrey Schwartz, P32076. I'm here on behalf of Mr. Jefferson. We're ready to proceed, move to sequester witnesses. I understand they already have been in charge, or at least standing here. I have no objection to that.
Okay, Mr. Jefferson, can you state your full name for the record, please?
Oh, Kevin Jones.
Thank you. If there's anyone on YouTube or on Zoom who may be a potential witness on this case, now's your time to log off. The people, I'm sure, joining that usual procedure registration.
Yes, if the victim advocate is here, do you have any objections to the?
No.
No objections.
Okay, that is why your first witness, if there are no other preliminary matters.
No. Well, we can do it first if we want, but is he in the courtroom?
No. Okay.
Okay, well, before, Your Honor, I guess there is one preliminary matter. I thought we were gonna do it after the testimony, and since the witness isn't here, the prosecutors agreed to stipulate that there was a search warrant executed. Well, first of all, that after the arrest of my client on March 22nd, that he had a medical situation and he was brought to the hospital. That's the first stipulation. Correct. And the second stipulation is that a search warrant was executed on his household after he was arrested, and that no firearm of any kind was recovered. Thank you.
That's all. That, Your Honor, people call complainant Brazil Christopher Tate.
Oh,
Spell your first name, please.
Excuse me, big topic is
T A
close.
Y.
It's okay.
Thank you.
Thank you.
Sir, raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth. So the door opens right here in the front, have a seat. And you can hold that microphone in your lap. You move. Ready to get that? Have you ready?
Thank you, Your Honor. Sir, could you state your name for the record?
Sorry.
Okay, and what brings you here to court today?
Neighborhood 357 out of.
And did that occur on March 22nd?
Yes, sir.
2023?
Yes, sir.
And did that occur around the area of 8114 Hendry?
Yes, sir.
Okay, and what's at that location?
That's off of Van Dyke, between Crash and Parker and Maxwell.
And that's in the city of Detroit, County of Wayne?
Yes, sir.
And what were you doing at that location?
I live there. I live across the street. My home is across the street.
Can you tell the court what occurred on that day?
I was working on my car and I had the hood up and went in the house to get a tool. He came out. He said, "Hey, I'm gonna kill you." Curse words.
Okay.
Pull it right back just a little bit. You're doing exactly what I asked. You're speaking up loudly, but it's a little muffled.
Is the person that you're talking about, is he in the courtroom today?
Yes, sir.
And could you point him out and identify a piece of clothing that he may be wearing?
Gray jacket.
Record should reflect that the witness has identified the defendant.
So stipulated.
And, where were you when you first saw him?
I was on my way to go into my house and get food. I was walking up, getting ready to walk up the steps.
What happened next?
He came out of the house. He said, I'm going to shoot you. So and so and so and so. He's 6 feet under. So, I kind of like ran. When I came back, he got a
Okay. Where did you come out?
I was coming from my car, walking to my home.
Okay.
Walking up the steps.
Okay.
Walkway.
And where did he come out?
He came out his front door.
And did at that time he have a weapon on him?
No, he said, wait right here, wait right here. And when I was going back to my car, he came out with the gun, pointed it.
Okay. And where was he when he pointed the gun at you?
And coming out his front door, he's standing on the porch.
That's his house.
That's his house.
What went through your head at that time?
I know he drinks all day, every day. So I kind of like ran in the house. When I came back out, I told him to come back out. Came back out with the gun again, pointed at me again. So when somebody drinks 24/7, 2 or 3 times a day, he's an alcoholic. I know you have to watch yourself because I don't know what his mental
Your Honor,
state.
I'm gonna object to a narrative that it's basically non-responsive.
When you saw the weapon, what was going through your mind?
Yeah, it's 357. That was good.
Okay. Well, after you saw the weapon, what did you do?
I went in the house. When I came back, I was on the phone calling the police. That's when I called the police.
So how many times did he pull the weapon on you?
Twice.
Did anything else occur?
Told me I deserved to be in the graveyard. He has been telling people, brother called me from Maryland, saying he was gonna kill me.
Okay, that is your
Okay.
say. Rules of evidence don't allow for everything to be entered, specifically because what someone else said, not the defendant.
You say you called the police.
Correct.
Did they arrive?
Yes.
Did you talk to them?
Yeah, so what happened?
Give them a description on
Yes, sir.
that? What did you observe them do?
So they went, at that time, he went in the house and shut the door, and he knocked on the door, and came out of the front door.
Anything else that you observed?
It was about it, and they arrested him.
I have nothing further.
Thanks, sir.
Thank you, Your Honor. So, sir, you and my client, the person you identified and claimed waved and pointed a gun and threatened you about the gun, you're neighbors, correct?
Yes, sir.
And you know each other a long time, correct?
Yes, sir.
Okay. And on that particular day, just before that happened, nothing unusual was happening. You didn't have any argument of any kind, isn't that correct? Yes or no?
I didn't spoke to him.
Okay.
Months.
So it's your testimony that he just came out of the clear blue and started cussing at you and pointed a gun and threatened you, correct?
He did.
Sir, is that what happened?
Sir, he did.
Okay, that's fine. And, can you tell me, then that's something that's very clear in your mind. That's something that you wouldn't forget the details about, isn't that correct?
Yes.
Okay. And the next day, you made a statement to the police, isn't that true?
Yes.
Okay. And when you made that statement, you had an opportunity to review it and look it over and make sure it was accurate, right?
No, I made a statement probably over the phone. I'm a witness.
Okay, well, so you think it was over the phone?
If they called me over the phone, and asked me what happened.
Okay, that's fine. May I approach, Your Honor?
Yeah.
Sir, I'm gonna hand you what appears to be the statement that was taken by one of the officers in that interview. I want you to read it to yourself, not out loud, and tell me when you're done.
No, I didn't.
Sir, I'm not gonna ask you anything yet. I don't want you to say anything until I ask you a question, but at the time, you've already said at the time you made that statement, everything was still fresh in your mind, correct?
Yes.
And you wanted to tell him everything that was important, correct?
Yes.
Okay, sir, you've had a chance to review that statement. Isn't it true that in that statement you said that my client came out of the house and cussed and pointed the gun at you right then? Isn't that what that says that's in front of you? Yes or no?
Yes.
Okay. And nowhere in that statement does it say he had to go back in to get the gun or that he came in and out twice and threatened you with the gun. Isn't that true? Yes or no? It's not in that statement, is it?
I don't understand, sir. Because that's
Okay,
not
all
what
right,
happened.
well, that's fine. I'm not asking what you're claiming is happening. I'm saying that you looked at that statement, right? Yes or no?
I'm looking at it now.
Okay, that's fine. I'll give you a chance. You tell me when you're done.
Okay.
Okay, so that statement says that he came out, was cussing you, threatened you, and pointed a gun. Yes or no?
Yes.
And nowhere in that statement does it say he had to go back in after coming out and cussing you to get the gun and pointed at you. That's not in there, is it? Yes or no?
I don't see it.
Okay, and it's not in there that he had to go back in and get the gun or that he pointed the gun at you more than once. Isn't that right? It's not in there, is it?
Yes, sir.
Okay, that's all I asked you, sir.
I told him that.
That's fine. I understand with that. But it's not in this statement, correct? Is that correct? Yes?
Don't understand.
Well, sir, it's not hard. What I'm asking you is, there's nothing in this statement that says that you say my client came in and out twice and pointed the gun at you twice. I'm not asking if you say that's what happened. It's not in this statement, correct?
Correct.
Thank you. Now, you called the police and they got there fairly quickly, right?
Right.
Okay. And they took my client away while you were still there, right?
Yes.
And you didn't see any gun on him when the police brought him out, right?
Right.
Okay. Thank you. Nothing further.
Redirect.
Your statement that you made to the police, that was over the phone, correct? Did you write that out?
Yeah, right. No, I just spoke from my mind. At that time, I was stressed out. And somebody pulled a gun on me twice. I think 57, not the happiest person.
Listen to the question, sir. You've never reviewed that statement, did you?
No.
I have nothing further on that.
Just a couple based on that. When the police officers came and arrested him, they came up to you and asked you to tell them what happened. Is that right?
Correct.
And that was even fresher in your mind at that time, right?
Correct.
Okay. And that's all I have. Thank you.
Nothing further, Your Honor. No further witnesses.
Okay. Sorry, sit down, Mr. Taylor.
Just one moment, Your Honor.
In the
I just want
hallway.
to check one thing. My apologies, Your Honor. I just want to see what's best. Is either Officer Robinson or Officer Jordan here? Okay, that's fine. They're not.
Wait a minute, hold on. Jordan's here.
I'd like to call Officer Jordan real quickly.
Okay.
Oh, I'm sorry.
Wait, okay, you got it, okay.
You still want, you still want, pardon me, you still want Jordan, correct?
I
Oh, I'm sorry, right. You do. Okay. Raise your right hand. You swear to tell the truth, go to the death.
Yes.
Have a seat. Right here, door, front. Right here, to the right. Just make sure you speak to the right.
State your name for the record.
Police Officer Mario.
And how are you employed?
But Detroit Police Department.
And were you so employed on October 22nd, 2023?
Yes, I was.
And were you called to the address of 8109 Hendry Street in the city of Detroit on that day?
Yes, I was.
Okay. And was that for an investigation of alleged felonious assault in progress?
That's
did you interview along with your partner, the alleged victim?
Yes,
Okay, and have you had a chance to review your report?
briefly.
Okay, if you need it to refresh your memory, you could let me know and I'll let you review it, okay? Now, is that a yes?
That's a yes.
Okay, so before you can't get your wave in your hand, that's okay, thank you. So, when you, well, actually, I'm gonna approach you, it's been a while since you saw this, correct?
I've seen it a few weeks ago.
Okay, but bottom line is that you do a lot of reports, correct?
Correct.
Okay, and sometimes it'd be helpful to have a look at your report to refresh your memory.
That's correct.
Would it refresh your memory as to some of the incidents if I handed you the report? Well, let me ask you this. Do you remember exactly what the complainant told you on that particular day without looking at your report?
Not verbatim.
Would it refresh your memory if I approach and let you look at it?
Yes, sir.
May I see the show?
Let the record reflect, I handed the prosecutor this gentleman and his partner's report. You can take a look at that, and when you're done reviewing it, you can let me know. Does that refresh your memory as to what the complainant said during your interview?
Yes, sir.
And is it true, sir, that the complainant said that the...
Objection here today.
No, it's a prior inconsistent statement.
Depending on the statement,
Pardon me?
depending on what it said.
Sure. Well, the court take it under advisement when I ask him? Okay. Sir, or officer, when you interviewed the complainant in the presence of your partner, did he tell you that the person I identified as his neighbor, Mr. Jefferson, came out of the house, cussed at him and pointed a gun at him?
From what I remember.
Pardon me?
From what I recall, yes.
And is that what the report refresh your memory on?
Yes, sir.
And isn't it true that nowhere in your report and nowhere did Mr. Jefferson tell, not Mr. Jefferson, I'm sorry, the complainant, Roselle Taylor, never told you that my client had to go back into the house to get a weapon and pointed at him? That's not the report, is that correct?
Should.
Okay, and also he never said that the gun was pointed at him more than once, correct?
I don't recall.
Okay, will this refresh your memory if I show it to you?
Negative. I don't think so.
Okay. Well, let me ask you this, that would be something that's pretty important to put in your report, right?
Correct.
Okay, so if it's not in your report, would it be safe to say that what was said to you is in this report?
Yes.
Okay, because you're not in the business of making inaccurate reports because you have a bunch of cases that you take care of and you have to refresh your memory by your report later on if you have to testify or if it comes into question, correct?
That's correct.
Okay, thank you, nothing further.
And I will allow for the response for Officer Burke.
Thank you, Your Honor, nothing further unless the prosecutor has some questions.
Officer, isn't it true that you don't always put everything that's said to you into your reports?
That's correct.
And again, the fact that someone pointed a gun twice at something is pretty significant, and that's something you would put in your report because it may have an effect on charges and testimony later on, correct?
Of course.
Okay, thank you, nothing further.
Officer Burke, you're all set, thank you. Any other defense witnesses?
That was,
That's it?
yeah.
Okay. Can we begin our witnesses as well?
Your Honor, people ask that the court find over the defendant on count 1, assault with a dangerous weapon, and count 2, weapon, felony, firearm, reserve argument.
Your Honor, I would object to the bind over under People versus King, where the court, People versus King, I'm sorry, the court has the opportunity to view credibility of the witnesses. The witness testified that shortly after this alleged incident took place, the police came. My client, by stipulation, was brought to the hospital due to some medical problems he was having that day. That an execution of a search warrant was executed shortly afterwards. No gun of any kind was found. No gun was testified as being on this person when he was arrested. And that the complainant's testimony is certainly severely questioned in the respect that his version today is completely different than his statement, albeit given on the phone, that my client came out, threatened him, came in, got the gun, pointed it at him, went back in, came out, pointed at him again. When in his statement to the officer that took the statement over the phone, it just says he came out, threatened him, and pointed the gun. And that the officers that responded, the officer, one of the two that responded right afterwards, confirmed that he was told the same exact thing, which is a contradiction. So I have asked the court to dismiss the case, or the alternative, certainly to get rid of the felony firearm.
Your Honor, we have further prove this probable cause. Witness testified that he was pointed, a gun was pointed at him by the defendant, whether it's once or twice. He stated that he told the police officers that this fact, whether that they did or did not write it down, is also a question of fact. But he did tell, according to his testimony, he did tell him. The officer's own testimony indicated that he's not sure if the defendant, or I'm sorry, witness said it was one or two.
Well, Your Honor, I'm going to object, and I hate to do that during argument, but that's not accurate. The officer said initially he didn't recall that being said, and then when I went over again with him about how he does his reports and whether that would be important, and the court heard that testimony, but he certainly did not say that he may not have said that. That's not the case.
Actually, I don't remember the first time, I do remember the second.
He is correct.
Okay. Anyway, this is definitely a question of fact of whether or not defendant pointed the gun once or twice. Witness testified that it was twice. He testified, especially on several times that he told the police officers, especially the one on the phone, that it was twice. He's not responsible for what police officers actually put into the reports. He didn't review the statement. So his testimony is that he did it twice. The defendant showed the gun twice, and it's our contention that is enough by defendant over on all charges. Thank you.
For our two witnesses, I will not go through the testimony. There were some inconsistencies between testimony from Mr. Taylor and his police report. To see whether the defendant went into the house and back out, and whether the gun was pointed once or twice at him. However, the district court standard or district court level, and People v. King was cited, and more recently, People v. Anderson, which relied on the Yeltsin case, says that the witness's lack of credibility when considered together with other evidence presented during examination is so lacking that a person of ordinary prudence and caution would not conscientiously entertain a reasonable belief of the accused's guilt. A magistrate may not bind over the defendant for trial. In this case, as I say, there were some inconsistencies, but I do not consider it so lacking that a person of ordinary prudence and caution would not conscientiously entertain a reasonable belief of the accused's guilt. I think this will be a question of fact for the trier of fact. To go through the elements first, the people have to prove at the probable cause standard that the defendant either attempted to commit a battery on Mr. Taylor or did an act that would cause a reasonable person to fear or apprehend an immediate battery. Mr. Taylor never wavered that he saw a gun, and that would be a question of fact for the trier of fact whether that's believable, even though there was no gun recovered. Second, that the defendant intended to either injure or to make Mr. Taylor reasonably fear an immediate battery. I think there was testimony that he feared an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought he had the ability. In this case, Based off of testimony from Mr. Kelly saying that he observed the gun, the defendant appeared to have the ability. And fourth, that the defendant committed the assault with intentional weapon, in this case, using the gun that Mr. Taylor testified. So with that, I will have Mr. Jefferson bound over for out of custody, so it'll be exactly 2 weeks from today, 8/19 at 9:00 a.m. Frankfurt Hall of Justice for your record.
Thank you, Your Honor. Have a good weekend.
The witness is still out there.
Yeah, we know, that's correct. Thanks.